Welcome to the Only Male Cruise Show, the podcast. I am the only Male Cruise. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work. All right. Welcome to the Only Male Cruise Show, the podcast. I am the only Male Cruise. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. All right. I may be the only Male Cruise, but I'm not the only one covering this Kelz case. All right. So I'm trying to get in where I fit in. All right. So first and foremost, the Judge Harry, has gone ahead and approved or accepted or granted the government's motion to have a delay in submitting the information. So they have until tomorrow to respond to the motions that Derrel's attorneys put in, compelling that they disclose this, that, and 2/3. So Judge Harry ruled on that earlier, earlier this morning. I just checked Pacer again, and that ruling was in there. So nothing else new from Bongine yet, but we know it's coming because over the weekend on Twitter, she said, be checking for the case because we can expect some, there we go. We can expect some stuff to be dropping like it's hot. Now, also on Friday, I said, yeah, it's a we on your ass weekend. And, I thought that Bongine and Derrel's attorney and the government were going to be dropping motions throughout the weekend because there's nothing precluding them from doing so, but they didn't. But what was dropping like it's hot was all of these other YouTube channels. Oh my goodness, sounded like there was some confessions going on. Where's Usher at when you need him? Sounded like some confessions, sounded like some beefing back and forth. I mean, shout out to April Showers in the chat. April Showers, y'all go check out April Showers' channel because she went on ahead and laid down some law. Right on, April Showers. Shout out to you for pulling up. Tiff J40, good morning to you. Thanks for pulling up. Lovable Leo, I appreciate y'all pulling up. And those of you in the bushes, y'all be sure to hit the like button, share, subscribe. All right, let's get into it, y'all, because these grandbabies are still on deck. And so y'all know what that means. All right, so Derrel's attorney, I'm just going to get right into it. They stated that the 2008 trial of Kelz in Cook County, Illinois, was replete with dishonesty, extortionate demands, admittedly lying witnesses, and a failure to truthfully identify video evidence used in that case, which damaged the integrity of the entire trial proceeding. Thank God that Kelz was acquitted now that we find out that there was dishonesty, extortionate demands, lying witnesses, etc. Derrel's attorney goes on to say that during the 2008 trial, the Cook County State's Attorney's Office provided to the defense expert what it told the jury through stipulation was an accurate and exact copy of a video that was received by the Cook County State's Attorney's Office from the Chicago Sun-Times. So you guys know how you'll be in court and they'll be like, yeah, Your Honor, we want to admit into evidence this video. And the defense can say, well, we want to see it first. But the defense at that time just stipulated and said, yeah, what they're about to submit is true and accurate, etc. Well, now we're finding out that it wasn't a true and accurate videotape. Derrel's attorney says, however, it turned out that this stipulation to the jury was false. The copy provided to the defense expert was not an exact copy. Some material from the original was not present on the copy given to the defense expert. Now, I wonder what was missing. Therefore, the defense experts showing a video segments to the jury, which he was told by the state came from an exact copy of the original. It actually turned out to be from some incomplete and inaccurate version. Okay. The 2008 jury was ultimately shown segments of two separate videos and falsely told by the state that what they were seeing was all coming from identical copies of the original. In other words, false affirmations were made to the jury by the state about what video they were seeing. When confronted by the fact that the jury was given false information by the state, Judge Vincent Gahn, I think that's how you pronounce his name, this is what he said. This is the thing that's in the barrel. This is the rotten tomato in the barrel, and I want some explanation about it. This is not true. I expect that Judge Harry should have some type of commentary about that as well, based on the fact that, with these emails that your girl Kroll was running, this Homeland Security agent, I expect Judge Harry to be like, wait, hold up. Now, why did you do this? People need to be held accountable. Shout out to Tatiana Harris. Sorry, girl, just make sure you hit the replay gang there, Tatiana. Thanks for pulling up, though. Shout out to Alexis Monet in Living Color TV. All right, let's keep going here. So Derrel's attorney goes on further to say, it is now apparent that the rotten tomato, which befouled the barrel back in 2008, continues to taint the evidence that the government now hopes to present to the jury at the upcoming federal trial. So it's a chain of custody issue here at this point. So insufficient chain of custody and authentication. On August 5th, counsel for Derrel went to the Homeland Security Office in Lombard, Illinois to view video 1, which the government has purported to be the video that was at issue in the 2008 trial, and which they intend to show to the jury in this trial coming up on the 15th. All right, so prior to going to view the video, both Mr. Glausman and Mr. Brindley independently advised the government that they wished to view any and all videos that were shown to the jury in 2008. Now, with this trial coming up, that shouldn't be a problem. They should have been like, yeah, we got coffee and donuts on deck for you. We'll see you when you get here type thing. The content of the video that was shown to the jury back in 2008 and which was provided to defense back in 2008 surely had an impact on the mindset of the attorneys representing Kelz at the 2008 trial and on Derrel, who was working with those attorneys as a member of the defense team. Now, that's interesting because that's a little tidbit I didn't know. So Derrel, I wonder, is he helping his counsel with that, if he brought this to their attention? All right. The undersigned could not have imagined that there would be a problem identifying the videos that were admitted. The undersigned could not have imagined that there would be a problem identifying the videos that were admitted into evidence as exhibits during the 2008 trial. The undersigned was wrong. On August 5th, at that meeting, it became absolutely apparent that the government has no idea what video was actually admitted into evidence and shown to the jury. They have multiple CDs that they contend are copies of the video that they got from the Cook County State's Attorney's Office. However, they have no idea whether the video that they have was shown to the jury and admitted as Exhibit 1 at the 2008 trial. They have no idea whether the video they have is the inaccurate copy of that video that was referenced in Exhibit 78 at the trial, shown to the jury and provided to the defense expert as the rotten tomato. To that end, the government could not tell Derrel's attorneys what happened to the state's exhibits that were admitted at trial in 2008. Now, y'all know that don't make no sense. It's sloppy work. More sloppiness. Nor could they tell them whether accurate copies of those exhibits were actually turned over to the government in this case or not. And this is starting to make it clear as to why the government was really trying to be so tight on how they can be questioned, who can say what, etc., etc. Because they know they didn't have their stuff together. This is ridiculous. A few days before this new trial starts. All right, the agents who made the copies were readily willing to admit that they have no idea which of these videos, if any, was actually the same video that the jury and defense counsel saw back in the 2008 trial. That means that there is, based on the current chain of custody, no way to determine what video Derrel and the defense team could have actually seen back in 2008. Nor is there any way to determine if the video the government wants to admit now was actually the same video that was shown to the witnesses in the 2002 grand jury, about which those witnesses are expected to testify at Derrel's upcoming trial. And that's really important because part of those charges is that they lied. That's why they want to bring that memo in that I think it was Van Allen that signed. They want to bring that in as though they were trying to lie and withhold facts about this case. And they're trying to hold Kelz and them responsible for that. All right, so it is impossible to discern how the government could claim a complete chain of custody has been maintained when they do not have a clue what happened to the videos that were actually the exhibits in the 2008 trial. And they do not have any way to determine whether the videos they have are indeed the same ones that were available to the parties back in 2008. The matter was made even more absurd when the agents showed the defense team a VHS videotape in an evidence bag, which they said was the video that came from the Cook County State's Attorney's Office. However, a quick review of the label on the VHS tape said it was a copy. Yet, neither the agents who are handling this case for the government nor government counsel knows the following things. Government counsel nor the agents know what exactly happened to the tape, what exactly that tape is a copy of, who in Cook County made the tape, whether the content of that tape was ever accessible to the parties between the 2002 and 2008 or the 2008 grand jury, and whether it is actually a copy of the tape provided to the state by Jim DeGrotus in 2002. Mr. I'll plead the fifth. Yeah, I'd plead the fifth too if I knew I was up to some, allegedly, up to some shishuckery. Okay. They have no earthly idea whether the video they have is really the same one that was used in 2002 to show the grand jury witnesses. They want to show this video they have now, video one, to witnesses and ask them if they made false statements about it to the grand jury back in 2002. But to do that, they have to be able to establish that what they have now is the same recording these witnesses saw back in 2002. Why is this? Why? You know what? Kel's poor defense team is the reason why these government prosecutors really wasn't trying to be on top of their game. Because they was like, oh yeah, he got some lame attorneys on deck. So shoot, we can cut corners, we can trip, we can slip, we can slide. But see, it's catching up to him now because Bone Jean's on deck. All right. Let me see here. All right, the government cannot do that. This was apparent to the undersigned based on the befuddlement that defense counsel encountered when simply asking to see different versions of the tape that were referenced and admitted into evidence at the 2008 trial. It appears the government does not know whether what they have is what was shown to these 2002 witnesses or not, or whether what they have was shown to the 2008 jury, or whether what they have was made available to the 2002 defense team and their expert. This is not an acceptable state of affairs in a case in which the obstruction of justice conspiracy surrounds issues related to this recording that was at the center of the 2008 trial and the 2002 grand jury. The only recording that is relevant to the obstruction of justice conspiracy is the video that was received by the Sun-Times in February of 2002, provided to the state and presumably shown to the grand jury witnesses in 2002, and again presumably shown to the jury at the 2008 trial. To establish a complete chain of custody such that we can have confidence that the video they intend to show is the same video that was available to the defense and thereby to Derrel in 2008 and shown to the grand jury witnesses that they want to call in this case, the government must be able to prove that the video they have is a copy of the actual video received by the Sun-Times in February of 2002, turned over to the state in 2002, and shown to grand jury witnesses in 2002, made accessible to the defense prior to the 2008 trial and shown to the jury at that trial. Now, that's not a lot to ask for. That's not a lot to ask for. And for the government to want to go way back in the day and try to hold Kelz accountable by using this RICO, it seemed to me like y'all would have all y'all ducks in a row. But you don't. That recording is the one that is relevant to the obstruction of justice. An entire trial in 2008 was held over the question of whether that recording was authentic and unaltered. Yet, at present, the government cannot tell anyone what happened to that specific recording. They do not know if they have it. They do not know if it was copied or who copied it. They do not know if it even still exists. They presently cannot say whether the recording they have is the inaccurate and compressed recording that embrued Judge Gaughan's trial in 2008, if it is the recording turned over to the state by the Sun-Times, or if it is some other version that has surfaced over the years, aka in Pennsylvania, okay, up in the attic. Y'all tell me when the last time Kelz was up in Philly, okay? And hold on, I want to run this note real quick. There was a note on here. All right. A quick little note here says, DeGrotus at the Chicago Sun-Times. Wait, hold on. Here we go. The source of this video, who sent it to the Sun-Times, remains anonymous. Where'd you get the video from, DeGrotus? Where'd the video come from? There has never been any explanation of who or how many people were involved in the transmission of this video to Jim DeGrotus at the Chicago Sun-Times, nor has there ever been any explanation of how many times the video has been copied before the apparent copy of a copy reached Jim DeGrotus at the Sun-Times. Boy, these people is playing confidently too. Let me see. I lost my place trying to get to that. Wait, hold on. Let me keep on scrolling down here to that end. See, the agents who made the copies were readily willing. Says the agents who made the copies were readily willing to admit that they have no idea which of these videos, if any, was actually the same video that the jury and defense counsel saw back in 2008. Now, hold on. I think I read that part already. Yeah. Let me see. It is impossible to discern how the government could claim a complete chain of custody has been maintained when they do not have a clue as to what happened to the videos that were actually the exhibits in the 2008 trial, and they do not have any way to determine whether the videos that they have are indeed the same ones that were available to the parties back in 2008. The matter was made even more absurd when the agents... It's raining right now. Play outside later. Get over there. I'll be right with you. All right, thank you. It says, and they do not have any way to determine whether the videos they have are indeed the same ones that were available to the parties in 2008. Now, let me see here, y'all. Hold on. All right, they have no earthly idea. They have no earthly idea whether the video they have is really the same one that was used in 2002 to show the grand jury witnesses. They want to show this video they have now to witnesses and ask them if they made false statements about it. I read that part. So this is not an acceptable state of affairs. Hold on, y'all. I'm trying to scroll down here. All right, to establish a complete chain of custody such that we can have confidence that the video they intend to show is the same video that was available to the defense in 2008 and shown to the grand jury witnesses that they want to call in this case. The government must be able to prove the video they have is a copy of the actual video received by DeGrotus and turned over to the state in 2002 and shown to the grand jury. All right. Hold on, y'all. Okay, that recording is the one that is relevant to the obstruction of justice. Okay, here we are. An entire trial in 2008 was held over the question of whether that recording was authentic and unaltered. Yet, at present, the government cannot tell anyone what happened to that specific recording. Where's it at? They do not know if they have it. They do not know if it was copied or who copied it. They do not know if it even still exists. They presently cannot say whether the recording they have is the inaccurate and compressed recording that had Judge Gahn say it's a rotten tomato up and through here. Hold on. Now it says if they cannot tell the court or the defense even that much, then they cannot establish that the recording they wish to play to the jury is authentic or that a proper chain of custody has been established. If the government intends to show a video and claim that it was the same video one that was at issue in the 2008 trial, then Federal Rule Evidence 901 requires the government to present evidence authenticating that it was the same video. To meet this burden, the government must establish that a chain of custody demonstrating that the tapes are the same and in the same condition, or testimony demonstrating the accuracy and trustworthiness of the tapes. But thus far, the government has fallen well short. The agents explicitly stated that they did not know which of their copies was shown at the 2008 trial or to the 2002 grand jury or provided to the defense. Worse, the agents cannot verify that the tapes have not been altered or are in the same condition. Whew. Now, Derrel's attorney cites a law here, Griffin versus Bell. And they're saying here, in Griffin, a video recording was inadmissible under Rule 901 because the proponent could not verify that the video was authentic and could not say how the video was made or whether it had ever been altered. And so he goes on and says, here we know that there was, at the very least, one altered version of the tape created by the state, the one that was provided to the defense prior to the 2008 trial, and which became the rotten tomato in Judge Gahn's, I don't know how to pronounce this man's name, but it was the rotten tomato in Judge Gahn's trial. Without additional discovery to establish authenticity and chain of custody, the government cannot verify that they have the same tapes shown in the earlier proceedings or that their tapes are in the same condition. It appears that the government is preparing to sully the record in this case with the same tainted concoction that resulted from the rotten tomato so poignantly described by Judge Gahn 14 years ago. This court, Judge Harry, cannot let this happen. To admit this recording into evidence, the government must provide discovery establishing 1. A chain of custody leading from the government to the Cook County State's Attorney's Office to the Chicago Police Department to the hands of Jim DeGrotus at the Sun-Times in February of 2002. They also need to provide clear evidence indicating what happened to the inaccurate, compressed copy of the video referenced in the 2008 trial so that we can be sure it will not be shown to the jury in this case. And 3, clear evidence explaining how the government can prove that what they purport to show the jury is not the inaccurate, compressed copy from the 2008 trial. 4, They want evidence showing that what they have in their possession is the accurate and unaltered version of the video provided by Jim DeGrotis, rather than any lesser or perhaps more enhanced version. Because, there was some conversation about Kelz don't have a mole on his back, but in the video, the person had a mole on his back, or vice versa. So, yeah, y'all don't get to enhance and use the blur tool on whatever software y'all using. We want we want the truth. And how come y'all don't have a daggone chain of custody? What the hell is going on? Damn. Derrel's attorney says this is not difficult. At least it should not be. All the government has to do is provide to the court and to the defense two separate video exhibits. One that is the very video obtained by the state from DeGrotis and his Fifth Amendment ass, and another that is the inaccurate compressed copy that falsely claimed to be an identical reproduction of the original. These exhibits were admitted at trial. This should be within the ability of the United States Attorney's Office, and it certainly is their obligation to do so. Now, if the government cannot at least prove to this court that they have the actual exhibits from the 2008 trial, then they should not be permitted to admit this recording into evidence. Trial and grand jury exhibits are received for the purpose of being maintained. Damn, government, what the hell? The trial and grand jury exhibits are received for the purpose of being maintained. The government is telling the defense they have no way to know what happened to the real exhibits admitted during the 2008 trial. That is unacceptable. And y'all still won't bring up Kroll. Ask Kroll. Kroll, where them videotapes at? Agent Molina, because you're the one that testified at the grand jury. Where the tapes at? But shit, they missing like the tapes is missing. Shoot, let me check the comments real quick. I appreciate all y'all pulling up. Please understand, the judge needs to allow everyone to show up on court on Monday just to say this case will be dismissed for excessive corruption. To be a fly on the wall, to see this prosecution's face, girl, ain't you? Thank you, Tiffany Only, please. Ain't that it? If you haven't had the proper process for chain of custody for this video, how are we to believe any of your evidence and testimony is true and accurate? Dismiss this case with prejudice. Because now not only are y'all playing around with the tapes, y'all sending emails, possibly, allegedly, coercing minor one, talking to Jim DeGrotis, who been on Kel's ass from jump. Oh, man. Shout out to Too Persuasive in the house. Pink Ice. Shout out to you, girl. Thanks for pulling up. I appreciate y'all. Candy, what's tea, girl? Shout out to all y'all for pulling up. Be sure to hit the like button. Share, subscribe if you haven't already. Let's keep it moving, y'all. So, let me see. Oh, my goodness. They're doing too much. So if they can't... All right. Here we go. The government intends to show video one to minor one and ask her if she made false statements about that video to a Cook County grand jury. If they cannot even prove that the video they are showing her now is the same video that Cook County received from DeGrotis in 2002, and the same video she was asked about back before the 2002 grand jury, then their chain of custody is woefully insufficient, and this video must be excluded. Right now, they have not and cannot provide that proof to the defense. Now, if the government couldn't even provide, hold on, let me get this. If the government needed 4 extra days, okay, because they were supposed to put that stuff in there. They were supposed to submit the evidence on Friday. But then they came back and told the judge, you're welcome. They came back and told the judge that they needed till the 9th. They needed 2 more days because they don't count the weekend as business days. But essentially, it was 4 days. Y'all needed Friday, Saturday, Sunday, Monday, and tomorrow to just get this little bit of stuff. Explain where Kroll is. Explain where Agent Molina is. Explain how many emails that they used the sidebar emails, covert emails. Y'all needed 4 days to get that all together. Ain't no damn way y'all gonna be able to satisfactorily explain where these videos are and which one is right and which one is this and which one is that. Y'all not gonna be able to do that satisfactorily by August 15th. Come on now, so stop playing. They need to throw this case out. In short, if the state has somehow lost the actual exhibits from the 2008 trial and no one can prove that what the government has in its possession is actually the same video that was received by the state in 2002 and referenced with witnesses in the 2002 grand jury, then the government cannot be permitted to show it to the jury in this case and pretend that it is actually the same recording that was discussed from 2002 to 2008 during the pendency of Robert Kelly's Cook County case. The government needs to obtain the actual exhibits from the 2008 trial and from the 2002 grand jury so they can establish a complete chain of custody and prevent Judge Gaughan's apocryphal, and I ain't pronounced that word right, but apocalyptic tomato from polluting the integrity of yet another judicial proceeding. Out of control. So wherefore defendant Derrel and them respectfully move this court to order disclosure of the items detailed above. And like I said, before I jumped on live, y'all, all Judge Harry did do was give the state more time to, he authorized them to go ahead and submit the first things that were requested, submit them by tomorrow. Okay. Y'all let me know in the chat. Do you think the government is going to be able to get these videos, get this stuff squared away? Shout out to you, Candy. Thank you, girl. Appreciate the compliment, y'all. Do y'all think the government's going to be able to? I don't. They got to tell me. That's not, come on. But they're so dead set, want to hem Kelz up. And here's the other thing. Right now, what does it say? That saying goes, an enemy of my enemy is my friend. So right now, Derrel and Bonjean and June Brown and all them, and bear in mind, we've yet to hear from June Brown's attorney. Y'all not going to tell me that this trial starts in 9 days? And y'all gonna get all these motions read, considered, fulfilled as far as what's being requested, and that nobody's gonna counter motion. And yet on the 15th at 10 a.m., when the bailiff says, all rise, that and y'all know that's not gonna go down like that. Judge Harry needs to say, hey, we got to hold up, y'all. But what I was saying about Bonjean and Derrel's attorney, they're working very, very cohesively at this time, okay? But trust and believe, if this trial goes on, and if somebody's back gets up against the wall, trust and believe, the two of them will be adversaries because both of them are fighting for their independent clients. But right now, yeah, they working like a well-oiled machine, and I sure appreciate it. Shout out to Too Persuasive. Would you say, oh no, I can't do the enemy of my enemy gets a side eye too. Ain't that it? Ain't that it? But that's how the saying goes. Tiffany Only Please said not by the 15th. They won't without probably compromising something. Absolutely. And we know that.
I'm sorry.
Shh, be quiet. Take this. And y'all, be cool. Let me get finished up here, okay?
Okay.
I'm sorry, y'all. These grandbabies. I got them up this morning, fed up some pancakes and some scrambled eggs, and I thought it's gonna be cool. But anyway, all right. Let me see here. Yeah, Judith, you said no. Ain't no way. Absolutely, ain't no way. There's no way at all. And what I want to see to make me feel comfortable is somebody, preferably Judge Harry, say, hey, you know what, y'all? We're gonna have to reschedule this. We're going to have to reschedule this because we got to get this shit cleaned up. Because if this trial doesn't go the way the government wants it to, and Kelz And when Kelz is free, then what? Y'all gonna try to come back again? Because you didn't have no problem with this. Come on now, this is they out of control. They out of control. Pink Eyes, what you said? Corruption at its sloppiness. Ain't that it? Because it's damn sure not at its finest, girl. Ain't that it? Yeah, Tiffany only please, girl. They some powdered donuts, and they came at me this morning talking about, oh, Granny, we want some Pop-Tarts. But I pulled a fast one on them the other day. I went on ahead and ate that last little pack of Pop-Tarts on them. So I told them I'll get them some more. But y'all, I don't know. I'm going to tell you what. I'm going to be popping up and on live as soon as the next motion pops up. I'm coming through. So y'all, hit the like button, subscribe, hit that bell so that you'll know when I come up. And like I said, everybody's covering it, y'all. Hit everybody's like button, subscribe to everyone. I appreciate y'all's support. But we just going to see. We are going to see, and we need to know what Judge Harry is going to do, how he's going to rule on these motions. Because now we're looking at like two separate things. We're looking at, we need you to tell us, government, we need y'all to give us a thorough explanation of Kroll and Molina. And I mean, this better be an 80-page damn motion. Y'all better be explaining what the hell happened to Kroll, why she's no longer the lead prosecutor on the case, and how come a motion indicating her withdrawal was not entered. Because for those of you who access Pacer, y'all see every time an attorney gets added to the case, that's done in writing. So, and then I know there was issue when the attorneys were trying to get off Kelz's case from New York. So where you at, Kroll? Where you at? And they better not say the girl's in a coma. Because that ain't even gonna fly. Okay? So we need full answers on this email, why you created this sneaky email, this covert email. How many covert emails did you create? How many times did you holler at the Grotus? And, the Grotus, because he claims he's press, can do that. Can do that Fifth Amendment. I'm a journalist. I don't have to disclose my sources. But damn it, you need to answer this question. How many emails did you get? And his email stuff should be able to be subpoenaed. But then they also want phone records, landline and cell phones. So that in and of itself is what is supposed to be being given up by tomorrow. And if the government was about it, they would have that stuff turned in. They really would have had it turned in on Sunday. If you couldn't get it to us Friday, you could have damn sure had it by Sunday. So if it takes y'all all day tomorrow to finally get this stuff, then y'all's on some BS up and through here. Tiffany Only Police said we need to go all into next week, unmuting R. Kelly with the hashtag and getting his royalties up, playing his music all week. Ain't that it? Candy said, Mel, one of the vids looked to me not R. Kelly, but Levi. Wait, girl. Wait, hold on. Without sounding rude, but it was so long more. Ooh, Candy. Girl, I'll drop this link if you want to pull up here real quick and explain in detail what you talking about. Now, look, say yes or no. You want me to drop this link, Candy, for you to come up here and elaborate? Say what? Because, I know these players, and if I didn't know them, I know who they are after this weekend. Ooh, them streets was hot. Tell me. Candy? So you said one of the videos looked to me not to be Robert Kelly. See, I don't know, but with this Dota, but Levi's. I don't know, Kelly. Candy, tell me if you want me to drop this link or not. Let me see. Lisa Levere. What's going on, Lisa? Thanks for pulling up. Appreciate y'all. Now, Candy, got shy, girl. All right. So anyway, that's what we should be getting tomorrow. Okay. But like I said, if the government was about it, they'd have had it Sunday, or they damn sure would have it today. So now we're also expecting to hear from Judge Harry, which I wonder when he's going to rule on this about these videos. And if y'all remember, even with Ann Donnelly, now we know Bongine had those motions in there for a new trial or acquittal on Kelz in that new trial. And Donnelly waited until the day of the sentencing to rule on those motions. Okay? And I said she was going to do that. And she waited until the day of the sentencing to rule on those motions. Judge Harry, you better not do this. Now, when it comes to these videos, you need to, let me take a page out of T.I.'s book. You need to expeditiously rule on this motion. What's up with these videos? Because if y'all can't put the videos in, can you really bring minor one in? Because that's the only reason why you're trying to bring it up. Pink Eye said, throw the whole damn case away. Ain't that it? And set fire to that mug. So, all right. That's pretty much it. I asked Candy to pull up and break it down, girl. So we could be clear, baby, on what you're trying to say. Because you might have a point, but I don't know. Judith Blank said, government's back is against the wall. Yeah, their back is truly against the wall. Let me see. Where's the 100 devices at? Thank you. And what did you do with them? Now we need to get that stuff checked out. We need to get that checked out. And yeah, expeditiously. Shoot. So I don't know, y'all. Like, share, and subscribe, because the next motion that comes up, it's going down. It's going down. So for the most part, y'all, that's it. That is the podcast. So be sure to like, share, subscribe. Replay gang, you know what time it is. Leave a comment, because you know I want to hear from you. And until next time, y'all, we will see ya when we see ya. Welcome to the Only Male Cruise Show, the podcast. I am the Only Male Cruise. Be sure to hit the like button, share, subscribe. Replay gang, leave a comment. You know I want to hear from you. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Let's go to work.